I will pass it over now to Councilmember-elect, because I know that you are just about to join another event. So we're very grateful for you taking your time to join us this evening, and welcome you here, and want to publicly congratulate you on your new position and say that we're very excited to work with you.
Well, thank you so much, Sarah. I am super excited to work with BKA. Brooklyn Legal Services Corporation A has been on the front lines protecting tenants and fighting for racial justice, and for over 50 years across not just North Brooklyn, but Central Brooklyn, and really deeply appreciate the work that you all do, and really appreciate this timely conversation, because I think we are all scared about what the future has to hold. And it starts by getting the foundational information from the partners we trust, like BKA. Evictions are violent, and the fact that we've been able to impose a moratorium over these 18 months has led to tens of thousands of fewer people in our shelter system, because evictions, of course, are the #1 reason that people enter our shelter system. And my goal in the council is for us to do everything we possibly can to stop evictions from happening. And we're really excited to partner with BKA to do that, and really appreciate y'all sharing critical information with us now as we begin to look ahead to what is likely the end of this moratorium, unless something dramatic happens in Albany. So thank you for bringing up folks together. I'll put my contact info in the chat if I can be helpful in any way. I'm sorry to not be able to stick around, but really deeply appreciative of the opportunity to be with you all, and for this great forum.
Thank you so much, Council Member. We appreciate your dedication to the cause and look forward to working with you. Okay, can we go to the next slide, please? Okay, maybe you just learned about Brooklyn A today through a social media post, or you've been a longtime friend for over 50 years, as the council member mentioned. But we just want to take a little bit of time briefly to share background information about who we are. So since our founding in Williamsburg, Brownsville, and East New York in 1968, Brooklyn A has used high quality, low barrier, neighborhood-based legal and advocacy tools to disrupt cycles of economic and racial injustice. We represent low and moderate income individuals and families throughout New York City. I know our name is confusing with Brooklyn in it, but we represent people throughout New York City in all 5 boroughs. Our clients live in rapidly gentrifying neighborhoods where many residents and small business owners face displacement and illegal landlord harassment. Last year, we were able to serve close to 13,000 residential tenants, homeowners, taxpayers, and small business owners through our 3 program areas. And I just want to take a moment to mention our different program areas. So tonight, as you know, we'll be hearing about our work in our Preserving Affordable Housing program. This program is the one that does eviction prevention, helps tenants to make repairs and get essential services restored, like with the winter coming up, making sure that people have heat and gas, so super important right now. We also work with tenant associations to organize people's buildings, help to file for subsidies, and a lot of other things that Christy can talk about. In our Consumer and Economic Advocacy program, that's where we work on preventing foreclosures, helping to prevent deed theft and scams for homeowners. And we have our low-income taxpayer clinic, which helps to resolve issues with the IRS and New York State. And then our 3rd program is our Community and Economic Development program. This is our program that works with nonprofits and small business owners on commercial lease negotiation, renewals, and all kinds of things related to to transactional legal services. So if you or anyone that you know has questions or needs help in any of these areas, please feel free to reach out to us. You can reach us Monday through Friday, 9 a.m. to 5 p.m., though you can call or email at any time. Our phone number is info@bka.org. And our number is 718-487-2300. I will put that information in the chat as well. Please feel free to reach out to us, and I'll be giving that contact information at the end. Just a quick note on housekeeping before we get into the presentation. During the presentation, feel free to write questions into the chat. I suggest that you choose the option to write to all panelists and attendees so that everyone can see your question, unless it's something that's very personal. Then you can just choose panelists. After the presentation, we'll have time to go through those questions, as well as if anyone would prefer to ask your question verbally, you can do so by raising your hand, and we can call on you. I'll be keeping track of the Facebook to make sure that there's no questions over there. And without further ado, I pass it over to Christy Ortiz-Lamb, Director of our Preserving Affordable Housing Program.
Good afternoon, everybody. It is great to have you all here with us today. I just want to give you just a small little presentation on what life may be like after the moratorium, but also providing the current situation as we have it now. So first, the moratorium has been extended once again. I believe this is the third time it was extended. It is due to expire January 15th for 2022. It's highly likely that it may be extended again because the environment, at least on the ground, is that evictions shouldn't happen during the dead of winter. It is not set in stone, so there is a potential possibility that it won't be extended, but there's rumors going around that it may. So I'm going to explain the reasoning why I believe it may be extended. It's also because of the variant Omicron, and then the rising number of the increased cases of COVID, which has been happening. And I know that the mayor and the governor have potentially brought back some of the rules of not joining in groups. And so that is potentially the reason why I'm thinking that the moratorium might be extended. But if it's not, then we have to put certain things in place to kind of cover ourselves. Also, DOI issued a memo to all marshals that evictions are suspended indefinitely. And that is not, so that's a typo. It's not indefinitely, it's up to January 15, 2022. And that's only if a moratorium is extended. So I'm going to start with the housing court. Housing court is still currently open. It is open in the sense that all court staff and personnel are actually at the courthouse. This was different from the start of the pandemic, but since May of 2021, all court staff is present. They are dealing with all the cases that were filed during the pandemic and before the pandemic. The way that they're dealing with it is all cases that were filed prior to the pandemic are calendared in a part called Part Z. Part Z means that it was all the cases that were filed previous to March 2020 will actually be scheduled on the calendar. And the individual resolution part will issue a date, and you'll get a postcard in the mail. You'll also get a notification from your landlord that there's an upcoming court date. You also will be notified by legal services providers that there's an upcoming court date if you don't receive the notices from the court or from opposing from the landlord's attorney. And then new cases that were filed after August of 2021 are actually being scheduled in Part I. Part I means the intake part. The intake part means that you are going to be assigned an attorney, and then your case will be calendared from the date that it actually was filed. The intake part is only dealing with new cases, not the previously filed cases. Previously filed holdover proceedings haven't yet been calendared, but the court is starting to slowly calendar cases that were filed from March 2020 to August of 2021. And then the clerk's office is open for all types of filing. So there was a period during the pandemic where they weren't taking any new non-payments and they weren't taking new holdovers. That is no longer the case. All types of eviction proceedings are being filed and they're receiving court dates. The court dates are slow in coming. So if a landlord files an eviction proceeding in August, they potentially could get a date in November. So it is taking time to actually calendar those cases. Also cases that were filed from March 2020 to August 2021 aren't really being calendared, which is a good thing for tenants, because it is potentially possible that you will not have your day in court until after the moratorium is lifted, and even far after that. Also, you can file HPs and illegal lockouts. You can file HPs. HPs are cases that you file if there's repair issues in your apartment. There's no heat, there's no hot water, there's no gas, your ceiling caved in, your door isn't self-closing. It could be anything under the sun. It doesn't have to be an emergency. It could be something as simple as the window doesn't close properly, or it doesn't latch, or the lock on your door isn't working. So anything and everything that you need repaired in your apartment, you should notify the landlord. Give them a week or two to respond if it's not an emergency. If they don't respond, then you can reach out to 311 and the city will have someone come in to inspect within 72 hours of that call. The landlord will be notified by the city that you have called. And generally that's when they start reacting in the sense that they will do the repairs. If that doesn't happen and the landlord doesn't actually do the repairs, then you should 100% consider filing an HP action. You can reach out to us and we can try to assist you on the step-by-step process. We can also file it on your behalf, but you do have the right to file this action. Another action that you can file, which is also called an HP, is for harassment. If the landlord is harassing you, meaning they're trying to kick you out of your apartment, or constantly calling you and offering buyouts, or assaulting you, or verbally being abusive towards you, or constantly doing construction at all hours of the day and night, or filing frivolous cases against you in housing court. These are all forms of harassment. Also, if they don't actually do the repairs and you continuously give them access dates and they don't show up, that's another form of harassment. So you can file harassment. It's the same caption of an HP action. You just have to include those allegations within your complaint. And the court is calendaring all of those cases, and you can get a court date within 2 weeks, which is great. And then you can and should file an illegal lockout if the landlord uses self-help and actually changes the locks from your apartment. Also turns off the heat, turns off the electricity, turns off the water, breaks your toilet. If something like that happens, then that technically is an illegal lockout, and you can file an action in housing court to get restored to your apartment and also to get your essential services restored. So all of these are options for you to file. We can assist you in the process, or we can guide you on how to do it yourself. So the lifting of the moratorium, evictions will be able to proceed. That means it won't be a landslide in the sense that every case that was filed during March 2020 to the present will automatically be put on the court calendar. The court still has to schedule everything, and they're not particularly being, they're not speeding the process in regards to holdovers. So if there's a holdover filed against you, whether you live in a small building and the landlord is trying to evict you because they're trying to sell the building, or they're trying to increase your rent, these cases are still slow to be put on the calendar. So even if the moratorium is lifted on January 16th or January 18th, you are not going to be evicted that day. There is still a court process that needs to happen. Your case still has to be calendared before the court. When it is calendared, you will be assigned an attorney as long as you are living under 200% of poverty. And you will be provided an opportunity to kind of settle the case. And so it's not going to be an automatic eviction. Also, you must pay attention to any notifications that you get from the courthouse. You can't ignore them just because you know there's a moratorium. You still have to appear in court. You still have to reach out to the court. All of the court appearances are virtual, so you can appear by phone. There's no need to go into the courthouse for any court appearance. And with that postcard that they send out, it actually includes the contact information for the court, the phone number, and also the virtual link. So you have that. And then you can also call the courthouse to get that link. The court also provides additional safeguards. There's administrative orders from the court administration, which does not allow for default judgments unless the landlord files a motion. That is very different than the way it was prior to COVID. Prior to COVID, if they filed an action, they could actually get you evicted within a month or two if you did not show up. However, since COVID, the landlord has to file a motion before the court, set it down for a hearing. There has to be a hearing and determination. In that hearing, you'll be potentially set up with an attorney. So you would be able to put an answer, you would be able to represent your defenses in that case. So in the last few, maybe year and a half, I believe there's less than like 30 or so evictions that's happened because of these safeguards. And the safeguards aren't going anywhere after the moratorium eviction is lifted. And the reason it's not going anywhere is because the court cannot process the amount of evictions that are currently pending. They have to do it sort of as a slow drip, because if they don't do it that way, there would be a mass eviction on, and I don't believe New York City would be able to deal with that. Also, default judgments are currently being issued. That started in September of 2021. That actually means that if you do not appear in court, you receive the court notifications, you don't appear in court, you don't answer when an attorney is reaching out to you, then the court may issue a default judgment and you'll get a marshal's notice. That is a safeguard that they've done now. I'm not sure if that safeguard will continue after the moratorium is lifted. So please make sure you check your mail, make sure that you are aware of anything or any threats that the landlords are making about taking you to court or trying to evict you. Make sure that you call us, we can check, we can look in and do a search under your name to make sure that there's no case actually filed against you. So that's the default judgments. But as I spoke throughout this entire presentation, you have a right to counsel. There is an initiative that was developed back in 2016 by the mayor and New York City Council, which has officially passed law that every person who is facing an eviction in New York City, all 5 boroughs, regardless of the zip code, is entitled to an attorney. So that means if you are living under 200% of poverty and the landlord is evicting you for non-payment or for a holdover, you are entitled to an attorney. You will be receiving with your court documents a list of legal service providers. Also, you will be provided a phone number for HRA, which will assign you to a specific attorney. You can also call 311 if you want an attorney, and there's a hotline that will refer you to legal representation. So there are a number of different ways that you can be assigned counsel. There's no reason to do an eviction proceeding alone. Also, there's a waiver program that if you are above 200% of poverty, most legal services providers, if you have sympathetic reasons why you'd need representation, for example, you've been living in your apartment for more than 10 years, it's rent stabilized, it's very low rent. Most legal services providers will do a waiver of the income limit and provide you representation. So once a case is filed, the case is assigned to a court part where an attorney is scheduled to interview all tenants. And if no conflict exists, the attorney will appear on the tenant's behalf. The conflict only appears if we represented the landlord, one example, Or there's a conflict within the household. So if you have two roommates that are living together, one wants to stay and one wants to leave, we wouldn't be able to represent both. We would just choose the first person who actually reached out to us. So that's how it would work. And then evictions, in order to be evicted in New York City, which is very different than most other states and other counties within New York State, is that you have to have a judgment and a warrant. There's 3 ways that you can get a judgment and warrant issued against you. It's a default judgment, meaning you don't appear in court. The second is after you enter an agreement with the landlord saying that you're going to pay or that you're going to move, and you don't actually move or you don't pay, there would be a judgment and a warrant issued against you. And then the last is if you actually go to a trial, you could get a judgment and warrant issued against you. If you get a judgment and warrant, that means that the landlord would have to go to one of the New York City marshals. The marshal will submit documentation to the courthouse to get a good warrant. Good warrant means that all the documents are done properly and that everyone who is living in the household is actually named. And that the landlord has standing to actually evict the folks that are living in the household. Once they get a good warrant, which could take a couple weeks, they will serve on you a 14-day notice. The service can be done personally, it can be done by mail. So it's always important to open your mail. Don't let it sit, and also answer your door, particularly if you know that there's a judgment or warrant against you. The last thing that I would suggest you do, that if you actually do get a warrant of eviction and it has a New York City Marshal's name and number on it, you call them, you ask them, when is the eviction scheduled? They will tell you that it's going to be in 3 days, or it's not scheduled for today, but it might potentially be scheduled for the next day or whatever. You have to go to the courthouse and file an order to show cause. You can and should reach out to a legal services provider, particularly BKA, and we can assist you in filing an order to show cause. We do not, and I believe the city as well, does not want anybody evicted. And once the moratorium is lifted, this is going to happen more and more. And a lot of folks are thinking, how can they evict me if I'm elderly, or if I'm a single parent, or if I've been living in my apartment forever, or particularly if I've been paying rent, but it's a holdover proceeding. These reasonings doesn't stop an eviction, right? Just because you don't have a place to go doesn't stop an eviction. So you have to reach out to legal counsel to get assistance to stop an eviction from happening. And you cannot assume that the landlord won't evict you. You have to be proactive, and you have to be basically take charge of the situation by filing an order to show cause in the courthouse or reaching out to counsel so we could file it on your behalf. And I believe we have a frequently asked questionnaire, which we can provide to anyone who's asked for it. But that is the end of my presentation. And I'll pass it back to Sarah.
Thanks so much, Christy. So much good, important information shared. I want to open it up now for questions. So once again, you can write your question into the chat, or you can raise your hand and we can unmute you. So if you're unfamiliar with how to do that, you go down to the participants tab and go to that little hand and press it, and then it'll come up next to your name. So I see you have one person who would like to speak. Going to let you. Hello. Hello, who's joining us?
Arias Oliva.
Hi, thank you for joining us. What is your question?
Yeah, my question is, my landlord, he wants to do repairs, right? I told him for the last 3 months. So I decided to stop the rent, but I filed also complaint for 311.
Okay. I think it's a good idea to send a letter or an email or a text to the landlord and say, I'm not paying rent until you do the repairs. So it's clear.
I sent an email already to the manager. I went straight to the office. I called them, I told them many times especially because my daughter, they have a bad asthma, that's why.
Okay. So you do have a right to file an HP action. You've given them more than enough chances to repair it. You can reach out to us and we can assist you in filing an HP action. The contact information should be on your screen. The best way is to send us an email, info@bka.org. Just provide your information, exactly what you said today, and then we can have somebody call you.
Yeah, but I used to have a case with you guys over there, Adam used to have it, and Mary used to have it a case.
Oh, cool. Adam Myers?
Yeah.
Okay.
Yeah. He knows me very well.
Okay, good.
Yeah.
So I'm glad you have a relationship with us. We're more than happy to keep helping. So.
Yeah. We fought with this landlord, for the past maybe 10, 12 years, because they want to just control the rent in the building I live, That's why the reason I still there,
Yeah.
Because I fight in court with her.
And that's what you got to do. You got to just keep fighting. Sometimes the landlords don't learn. So I'm glad that you have the fighting spirit and we're here to help.
All right, thank you so much. I will do that.
Okay.
Thank you. Thanks for joining us.
Thank you.
Okay, we have a couple questions in the chat, and then I see a couple hands up. All right, so the phone number for the marshal's office.
So it depends on the marshal. So if you go on Google and do New York City marshals, there will be a list of all the marshals in the city. If you get a warrant of eviction, the marshal that is assigned your case will be right on top on the right-hand corner. On the document itself, it will have the contact phone number. If you are in fear of getting a marshal's notice and you didn't get one, you can call the courthouse. The courthouse's number is 347-404-9201. And you can ask them, who is the marshal assigned to my case? You just tell them the name and your address, and they should be able to pull it up. Also, if you have the index number or the case number for your case, you let them know that and they can tell you who the marshal is. So that's another way of finding out.
Christy, can you repeat the phone number for the court?
For Kings County, Brooklyn, it's 347-404-9201. You can also find that online.
Okay, great. Thanks so much. Okay. So, and how quickly does that office respond to eviction warrants and marshals?
So it really depends. If you entered into a stipulation with the landlord, which says that you have 30 days or 45 days to pay, it depends how long the landlord takes to get there and to actually put in the paperwork. It could take a week, 2 weeks. Before the moratorium, it took about a month. Because the marshals aren't very busy, it may be about a week or two. So it's not too much of a wait, but the notification is 14 days. So at least you'll get the extra 2 weeks.
If the tenant being evicted is hospitalized, can a member of the family go to court and file an OSC on their behalf?
100%, and you definitely should do that. And you just put in that the person is in the hospital, and generally almost every court will delay the eviction because of that. You can also do an APS referral where you reach out to Adult Protective Services, and then they will also stop the eviction as well.
William, I see that your hand is raised. That was just your question. So if that covers it, let us know, or if you still want to be unmuted, also let me know, please. Okay, my lease is expired. What should I do?
It really depends on what type of housing you live in. If you are living in a building with more than 6 units that was built prior to 1974, you're likely to be in a rent stabilized apartment or a rent regulated apartment. So in those types of apartments, you're entitled to a renewal lease. If you're living in an apartment with less than 6 units, then you're not entitled to a renewal lease, and you would have to negotiate with the landlord a renewal lease. And generally, they can increase the rent to whatever the amount they want. There's no regulations for unregulated apartments, unfortunately. So I think it really depends on where you live. And if you reach out to us, we can provide you advice on your specific issue.
Can you
Oh,
talk?
but
Sorry.
another thing on that is most landlords understand that it's very hard to get people out of their apartments now. So a lot of them are just renewing leases, because if they have a good tenant who is paying rent, there is a lot of negotiating power with tenants now. So perhaps reach out to your landlord and tell him or her that you want a renewal lease.
Can you talk a little bit more about the time frame of the eviction process? For example, how long from the initial court appearance to the beginning of the trial?
So it depends on what type of case. So I'll give you a couple of scenarios. So if it is a nuisance case, meaning they are alleging that you're a nuisance in the building, that can be Collier, that can be you assaulting folks, you causing issues in the building. Those cases are moving much more quicker because the moratorium does not apply to them. So you could actually have a court appearance, and within 2 or 3 months, you have a trial. And after that trial, the court can give you 10 days to, if you lose, the court will give you 10 days to vacate, up to a year. So it's up to the judge how long they will provide you the time. However, if it's a nuisance case, they're not likely to give you time. They'll probably ask for you to be removed from your apartment right away. In those cases, it's very quick. So unfortunately, that's quick. If it is a non-payment case, almost every non-payment case is easily resolved, particularly because the city will provide the funds, doing a one-shot deal, working with a lot of the charities around the city. They're helping with rental assistance. Also, we just had the program with ERAP, which is a state program which provided rental assistance. So in those types of cases, it takes a long time because the landlord really wants the money. So generally in those cases, they'll work with you. So you could have a case for a few months, even a year. Most of the cases that have been commenced prior to March 2020 are still happening now because ERAP is issuing their checks now. And so those can take, non-payment cases can take a while. Holdover proceedings also can take a while, particularly because they're not being calendared. And because they're not being calendared, you could technically get your first court appearance 6 or 7 months after you get your court papers, or sometimes even longer. So in those cases, it could be a while. However, if you actually do get a calendar date and you put in an answer, also you will be appointed an attorney. The attorney will see what defenses you have in those types of cases. If there is no moratorium, it could be 2-3 months before you get set down for a trial. Once that trial is set, if you have sympathetic reasons why you should be in your apartment, your children are still in school, you're a single parent, your income is low, you have a subsidy that needs to be transferred. These are all reasons that the court will give you time to move out. If you've been in your apartment throughout the entire moratorium, it's not likely the court's going to give you even more time after that. So I think it's a very specific question, and I try to give you all the potential scenarios, but it really just depends.
We have someone who seems to have a lot of extra charges on her rent statement other than rent. How can these charges be taken off and the rent fixed?
So I think it depends on your housing. So if it's like a co-op or a condo, then maintenance fees are generally described within your lease, and there's not really much wiggle room. If it's a rent stabilized apartment or it's unregulated, the landlord, actually let's split it up. If it's unregulated, the landlord can only charge you rent. There is no additional fees that they should be entitled to charge you, unless you make an agreement with them and you say, okay, I'll pay an extra $100 for water because I have 5 people living with me. That's something separate and apart. It's an individual agreement. If it's a rent regulated apartment, the landlord can try to charge you AC charges for a new stove and new fridge, and then an MCI, which is a major capital improvement, meaning they've spent more than $15,000 in your apartment to improve something. In those instances, it is a very small percentage because you only have to pay a portion of what the increases are. So it really depends on the type of housing, also what types of charges. I don't know if you can put that in the chat. Like, is it AC? Is it heat? Is it what it actually is? Also, you can get a rental history from DHCR if it is rent stabilized, and they can tell you the types of charges.
It is
the
rent
land-
stabilized.
Okay, good.
And
then-
then, and are you able to write any of what kinds of additional charges there are? Otelia?
Also, for the charges, the landlord has to give you notice, and if he or she doesn't give you adequate notice prior to the charges being added to your lease, you can actually fight the charges and you won't have to pay them.
AC charges for an AC that's not in the apartment.
So I would argue that you can reach out to us through the email or the phone number, and we can do an analysis about your specific case. You should call DHCR. It's located at 50 Hanson Place. I don't have the number offhand, but you call them and you get a rental history for your apartment, and then we can see what charges are allowed and what's not.
Great. So we have a couple of questions about ERAP. Can you talk about the legal protections provided by ERAP? And then, yeah, let's start there because the other question's a little bit different.
Okay, so with ERAP, there are a number of protections. The first is that the landlord is precluded from filing a case against you for up to 12 months after you applied for ERAP. If the landlord doesn't participate in the program and rejects the money, he is precluded from starting an eviction proceeding against you for that money. Also, there's a protection if the landlord accepts the ERAP money that they can't evict you for 12 months. So those are some of the protections.
Okay, we have someone that started an ERAP application, sent it to their landlord to upload his info, but he never did and asked that the tenant did it. Then he took back to court for non-payment. Can I still get my ERAP funds?
So you should notify the court that you have applied for ERAP. Unfortunately, the funding for ERAP has closed, but if you had an application and it was being processed, I believe they're holding on to those funds. So I think you might be in a good position. So let the court know your ERAP application number, your date of birth, and they will be able to look into it and force the landlord to complete the ERAP. Particularly if he's filing a non-pay, he's not really entitled to that because ERAP would have paid all the arrears.
What happens if a landlord files both a holdover and a non-payment case?
So it depends the order. So if he filed a non-payment case, then he can file a holdover, which is fine, but he can't file a holdover and then a non-pay because the non-payment will basically void out the holdover. And it really depends on the two different types of, or the type of holdover that they're filing against you. But yes, a landlord has the right to file both.
Is there any flexibility with HRA in terms of future ability to pay, or is this still a firm requirement for a one-shot deal?
It's a firm requirement.
Okay.
However, there's charities that don't necessarily have that requirement. So I would reach out. You could reach out to us and we can provide you that charity list, or just do a Google search and see which charities are actually providing rental assistance without future ability.
Okay, just a little bit more detail from the previous question. In the non-payment case was filed first, then the holdover, but the holdover is calendared. I don't know if there's any additional advice there.
So the advice would be to file a hardship declaration if you're eligible for that, which is nearly every New York City resident. And so then that would stay the holdover.
Okay.
But you should definitely reach out to us because we can represent you in both cases.
Yeah, Carolina, please reach out to us since I see that you have a hearing calendared for January 18th. So reach out to us as soon as possible and we'll.
If
that
it's
would be-
January 18th, I think you already filed the hardship declaration because that sounds like the date that they're actually calendaring. Okay.
Yes, yeah.
Okay, good. In that instance, if the moratorium is extended, it's just going to be pushed back and you wouldn't have to do anything.
If a landlord accepts ERAP funding, can they bring a non-payment case for rent not paid by ERAP in the last 12 months, in the 12 months following the payment? Or does the protection only apply to holdovers?
No, it applies to non-pays. So the landlord can't technically file a non-payment case for the money owed from March 2020 to technically the present. So if you owed money prior to March 2020, then yes, they can file. But during that window period, there isn't a valid defense that you can raise that ERAP was paid and it was applied to the appropriate months, and therefore the landlord's not entitled to those months of rent. And if he tries to evict you, the case will be dismissed, but they will sue you in civil court for it, not to evict you, but just to get the money. So it might be a good idea to try to figure out the money situation.
Great. And Renee, I just put that that point from the PowerPoint in the chat. So the DOI's Bureau of City Marshals phone number is in there, 212-825-5953 for anyone that's listening and can see the chat. Let's see, I think we may have covered all the questions in the chat. Let me just double check. If you asked a question and we have not gotten to it yet, feel free to write it again. I might have lost it. Okay. I thought landlords can sue you for months not paid by ERAP, even if you received ERAP for other months.
So they can sue you, but they can't sue you for eviction. So there's a distinction. So they can sue you in civil court just for the money, but they can't evict you for that period. And there's a valid defense within the statute for that. So if they try to sue you for an eviction, you just raise the fact that ERAP actually paid and allocated which months the landlord was entitled to.
What is the period that ERAP covers?
So it's March 2020, technically to the present, because they're still issuing money to the present. But the window technically was March 2020 to June 2021.
All right, I'm going to unmute Milton so that you can ask your question. And in the meantime, there's a question around if there'll be more funding coming through ERAP.
Yes, there is talks of additional funding. I know that there's going to be a release of a new rental assistance for co-op and condo owners, and that should be starting in January. So that's for folks who live in Michelama buildings, and they are talking about additional funding for ERAP. I know that a lot of the other like upstate counties still have money. I'm not sure if it's not used within a certain time period, they'll reallocate it to the 5 boroughs. But the need is there, and I'm sure the state is aware of it. So.
Great, that's exciting. Okay, Milton, we have you up here. Do you have a question? And are you, let me know if you're having trouble unmuting yourself.
Yeah, I have a question.
Okay, hello.
Yeah, if I did not pay my rent for 3 months and the following month I got city theft is not helping me pay my rent anymore, what should I do? And my lease expired in my apartment. I live in a 2-family home.
Okay, So there's a number of charities that you can apply to: Coalition for the Homeless, Catholic Charities. You could also apply for home base, it's called. Do you have future ability and can you afford your rent going forward?
No, I can't.
Okay, so once you do get a job or assistance in paying the rent, you could apply for a one-shot deal, but there are charities that can assist you. Has the landlord filed a case against you?
I think he's going to.
Okay, so in that instance, you would just reach out to us and we can try to help you. But reach out to the info line and we can send you the list of Catholic different charities. And then hopefully
Okay,
you can reach out to them and see if they can help you.
So what will I do about my expired lease?
The expired lease in an unregulated apartment, it's a hard thing to do, especially because you've had some issues with paying rent. It is really up to the landlord whether they provide you a renewal lease. You're not entitled to one in an unregulated building, unfortunately. So you would just have to negotiate with the landlord. And hopefully you have a good enough relationship with him or her that they'll let you stay.
Well, unfortunately, the landlord is not speaking to the landlord. It's kind of a hardship.
Okay. I would tell them to write a letter to them saying that they want to remain and if they can provide them a renewal lease. But there, as I said before, there's nothing under the law that mandates the landlord has to give them a lease. But they become a month-to-month tenant after that. So nothing is pushing them out unless the landlord starts a holdover. So their rent will remain the same. They don't actually need a lease in that type of building.
Thank you.
Thanks, Milton. We wish you the best. Okay, a couple more things in the chat. Is the FEPS increase in effect?
There has been an increase. I think it was just issued. I'm not sure exactly. But if you actually do a search on Google, it pops right up. And I believe for a family of 3, it's 2207. I think for a family of 4 or 5, it's 2800. So I know it did go up.
Okay. Okay. I'm not sure what this question is asking. What happens if you receive the notice that ERAP is paying rent for people that are not rent stabilized? Do you continue to wait?
Oh, so that you got an email saying that you weren't part of the emergent people, like the folks who had priority. If you receive that email, that just means that your application's on hold. And once additional funding comes, then you would be next in line. That's what that means. I don't know if the money will be forthcoming, but at least you have your application in, and so if money comes in, you're next.
Great. I think I just want to check in with
Facebook
and also with Renee to see if we covered their question. Hello.
Hello.
Hi. I wanted to see if we answered your question or not.
Yes, you did. Thanks. Appreciate it very much.
Okay, great. Thanks so much for joining us.
Presentation. Thanks a lot.
Thanks. Okay, great. Yeah, just checking Facebook. While I do that, Chrissy, what would you say is kind of like the most important points that folks should take away from this evening?
The most important points, I think, would be to reach out to your politicians, local politicians, and express the need for the extension of the moratorium. Also, you should 100% don't ignore any notification you get from the court or from your landlord. definitely reach out to us or any other legal services providers if you do get an eviction notice from a marshal. And so just know we're here and we're ready and able to assist you.
And on that point, I just see a question actually from my father asking, as the city and courts work through this process, do you anticipate BK holding added information sessions based on the changing conditions?
Yeah, I think we're anticipating doing another one in January, actually in partnership with the public library. And then we'll be doing one, I think, every month or every 2 months. So.
Definitely. Yeah. I believe that workshop with the public library is January 6th. Correct. Yeah. So we can send out information about that one if you want to come back and learn, hear this information again. If there's any updates, of course, we'll share them with you. And
also the administrative judge from Kings County will actually be part of that presentation.
Oh, that's great. So yeah, we'll be sending out that information as well as the PowerPoint and recording of this presentation. We thank you all so much for joining us. Thank you, Christy, for answering tons and tons of important questions. Thank you to our co-sponsors, Councilmember-elect Rita Joseph and Lincoln Ressler. And thank you all for joining us. And we hope that you have a great evening and holiday season and much success in the new year.
Happy holidays, everyone.